All rise, please. The United States District Court for the Western District of Washington is now in session. The Honorable James L. Robart, United States District Judge presiding.
Please be seated. Well, there certainly are a lot of you. Will the clerk will please ask for appearances?
Case C-12-1282, United States of America versus City of Seattle. Counsel, please make your appearances for the record.
Good morning, Your Honor. Mike Diaz for the United States.
Mr. Diaz.
Good afternoon, Your Honor. Tim McGatt for the United States.
Thank you.
Good afternoon, Your Honor. Andrew Myberg for the City of Seattle.
Marburg.
Your Honor, Peter Holmes, City Attorney for Seattle.
Holmes.
Ian Warner, now representing the City of Seattle.
Mr. Warner. You changed stripes.
Isaac Ruiz, representing the Community Police Commission.
Thank you. Go ahead, Mr. Bob. Part of the court team. We're here for a status conference in this matter. Let me give you a rough schedule of what I propose to do, and that is to lead off by giving you from fairly extended introductory remarks. That will be followed by presentations by the two parties, by the amicus, and by the monitor if he wants to correct anything that I've said. That was a joke. And finally, there'll be some additional closing comments by the court. The parties are aware that I've given them 15 minutes each. When we originally contemplated this hearing, it was before I issued my recent order in regards to the proceedings. And at that time, I intended to afford a longer period of time, but since it seems to me that the status of these proceedings now has shifted to some extent from the court to the city, I felt that a shorter period was appropriate. I'd like to take you back to July 27th, 2012, and introduce the two parties to this litigation, namely the United States of America, acting through the Justice Department, and secondly, the City of Seattle. This is an unusual litigation in that there are two parties, and most of the time there are at least 9 points of view. I've not encountered that before. The United States and the City of Seattle signed a settlement agreement and filed a proposed stipulated order of resolution. Accompanying that pleading was a memorandum of understanding, which is described as a contract between the United States and the City of Seattle, and it is signed by the same parties but not by the court. On August 30th, 2012, the court approved the settlement agreement and stipulated order of resolution, changing it from a proposed document proposing something to an order of this court. I think at times that is lost in the course of this litigation. Over the passage of time, that settlement agreement and order of resolution has been referred to almost exclusively as the consent decree, and the memorandum of understanding as the MOU. Bowing to popular pressure, I'll try and use those terms. So how did these documents come into existence? In March 2011, the Department of Justice initiated an investigation into an alleged pattern or practice of excessive force and discriminatory policing by the Seattle Police Department. In December of 2011, the Department of Justice issued a report concluding that, quote, the SPD, Seattle Police Department, engages in a pattern or practice of using unnecessary or excessive force. That's what took us to the consent decree. The role of the court in this is that after the consent decree was signed and entered, first, the court becomes responsible to see that the terms of the consent decree are followed and the proper forms of relief are accomplished. Secondly, as an order of the court, the consent decree cannot be changed, modified, or amended without court approval. That's true in every case in which I issue an order. The parties don't get to ignore it or modify it or adopt their own order. It is an order of the court. If I referred you to paragraph 2.5 of the consent decree, I think you will find that that's where it contains the provisions as to how you can change the order of the court. A misconception that I have encountered in preparing for this argument today, or at least the status conference today, is somehow the impression that the court has been given unlimited authority. That is not accurate. The court deals only with issues covered by the consent decree. And some of the proposed resolutions to issues that are implicated in this situation are well outside the scope of the consent decree. I'd now like to take a moment to discuss the progress to date. If you want some interesting nighttime reading, you can look at the index to the consent decree. In part, I think it is illustrative of the substantial progress that has been made up to this point. Some of those items, the ones that I've dealt with most directly, are the use of force principles. It would be fair to say that the court believes that it is better to have principles that prevent excessive force use than it is to concentrate solely on accountability for that excessive force use. The two go hand in hand in my mind, but we needed to radically change the use of force principles that the Seattle Police operated under. I'm pleased to say that we did. I frequently read now that the de-escalation techniques that were put in place and the training that goes with those de-escalation techniques is considered at least a national model. And by looking at the results in terms of what the police have been able to accomplish, de-escalation, while not universally accepted by the force, has achieved its intended purpose. Second would be weapon-specific policies. There was an absence, or at least a lacking of guidance for each of the weapons that are used by the Seattle Police in carrying out their day-to-day responsibilities. Guidance for each weapon was provided, including tasers, pepper spray, impact weapons, which I have learned means batons and flashlights, plus the lethal force weapon of a service weapon. Next, to my surprise when we started this, was the inadequacy of the use of force reporting. I think it would be fair to say that it was woefully lacking. You couldn't find out how many, where, or the result of many use of force situations. In response to that situation, the consent decree invokes something called Force Investigation Teams, FITs or FIT teams, that go to serious uses of force situations and conduct investigations if they were properly handled. The consent decree provides for a use of force committee that reviews these situations. One of the provisions of the consent decree that is, I think, critical is the Crisis Intervention Program. The Seattle Police encounter about 10,000 incidents a year which involve people who are in crisis. That's a nice name for people who are suffering mental illness, delusion, emotional breakdown. My colleague on this floor, Judge Peckman, is dealing with the inadequacies of the state of Washington's mental health program. And unfortunately, because of the absence of resources, many of those situations have been forced over onto the police. We have devoted substantial resources to mental health training. We now have officers specifically trained in dealing with people who are suffering a personal crisis. And the emphasis of the follow-up is a referral to resources as opposed to putting them into incarceration. In following up to one of the findings of the Justice Department, there is additional training and policies in regards to bias-free policing. I think the events of the last 6 months should be a lesson to all of us that we are not there yet. And I'm not sure that we can get there overnight. We need to change persons, police officers, perceptions, similarly to the way that my perceptions have to be changed when I have an assortment of individuals appearing before me. Those policies are in place, and we're trying. We have a specific provision in the consent decree regarding data collection, something that is now being effectively used, perhaps, by the first time by the Seattle Police Department. And lastly, in my list of 9 things that I feel progress has been made on is supervision. Part of that is the use of force teams. Part of that was the decision to make increase the number of supervisors, particularly the rank of sergeant, and to make them accountable for the people who are reporting to them. Is the system at this time perfect? No. Does it need constant attention? Yes. Is the city better constitutionally policed than when we started? Undeniably, yes. But we have a ways to go. That takes me to my recent order. In late 2015 and in the spring of 2016, the parties were discussing the next step in this, which is an optimal police accountability system. In a meeting which I attended with the CPC, we talked about how to get there given the rather siloed efforts that had been made prior to that time. The city had a plan, the CPC had a plan, the United States had a plan, and we just were not working on this on a collaborative basis. Therefore, we entered into a series of meetings in which the various groups talked about these issues. I'm not so Pollyannish as to believe that there was consensus on everything, but there was, to my delight, more consensus than perhaps was there when everyone was talking only to themselves. On July 6, 2016, the City and the Department of Justice asked permission to submit legislation to the City Council in the area of accountability. The court at docket 297 approved a modified order permitting the introduction of proposed accountability legislation from the executive to the City Council. Since there seems to have been some confusion regarding this, I'll simply read you the language that was submitted to me, which was, the parties further anticipate that the legislative process will include the following components. Number one, the introduction of proposed accountability legislation from the executive. That's what was asked for, and that was what was given when the court approved it. Consistent with the terms of the consent decree, the parties provided that such legislation shall not take effect until after the court has had an opportunity to review the legislation to determine if it poses any conflict to the terms or purpose of the consent decree. I would remind you again that this is the language of the City and the Department of Justice. On August 3rd, I received a letter from the CPC, found in the docket at 304, that said in its first sentence, "We respectfully ask that Your Honor sign the proposed stipulation submitted jointly by the City of Seattle and the United States on July 11, 2016. On August 9th, I did so. I made one change, a change that I thought was important. And that one change was that I changed the order in which the proposed legislation would be reviewed by the court from occurring after it had gone through all of the steps that are outlined in the stipulation to being reviewed by the court prior to the time that it was submitted to the City Council. I did that because it seems to me to be prudent that if the court finds some conflict with the terms or purposes of the consent decree, that the City Council be aware of that prior to their adopting the legislation. I didn't change the time frame so that it should go through in roughly the same period of time, given that the court has a substantial workload and sometimes doesn't get around to things immediately. At this point, it is the mayor, the executive as he's described in the consent decree, and the City Council that control the legislation, not the court. The mayor is going to propose something, the court is going to review it, and then it will be submitted to the City Council. What should that system look like? On I think it was August 1st, the court's monitor, Mr. Merrick Bob, who was introduced a moment ago, issued a letter that sets forth what he believed to be a synthesis of the working groups. I pause for a moment to thank Mr. Bob and also to acknowledge the team of assistant monitors who are amply undercompensated for the time and the effort that they put into this. Two of them are sitting in the front row. One, Ron Ward, who has, I think, attended more night meetings than probably anyone else in the room. And secondly, Peter Ehrlichman, who, when he's not out fishing, serves as the local contact for the monitoring team. Those working group meetings, along with discussions with the court, have been collecting views on what are the best practices. Mr. Bob summarized his views in the August 1st letter following consultation with the city and the Department of Justice. And I appreciate the thoughtfulness of their submission and have studied it. In preparing for this hearing and for the ultimate review of this document, I've also looked at a number of other sources. For those of you who want to be deeply involved in this, I would encourage you to read the Blue Ribbon Panel on Transparency, Accountability, and Fairness in Law Enforcement, which was recently prepared for San Francisco. I can honestly say that having read that, the city of Seattle is light years ahead of where San Francisco is. I've read the April 2014 reforms suggested by the CPC. I've read material from the OPA auditor. I've read material prepared by the CPC, including the material that it currently has up on its website. And I commend the CPC for its efforts to bring forth the community's point of view and involvement in this process. I don't intend to spend the next hour and a half going through each of the provisions that are discussed in those various sources. But I am going to highlight some of the things that I think everyone agrees is a good idea, or everyone agrees is an area that needs to be addressed but may not be in agreement with how to do it. First, and perhaps foremost, is that there is only one person who has spoken on this subject, and therefore I'm going to conclude that everyone is in agreement with him. And that is that the power to impose discipline rests with the chief of police. That seems common sense to me, in that someone has to be in charge. Second, as a broad oversight, I believe that what is described as civilian oversight of the SPD appropriately involves an Office of Professional Accountability or Police Accountability. Seems like we're migrating from one term to the other, to handle complaints of misconduct, and an Office of Inspector General replacing the OPA auditor to provide systematic oversight of the management practices and policies of the Seattle Police Department and the OPA. The third component of that relates to the Community Policing Commission, and I'm going to speak separately to that so I can try again to explain my view of the role of the CPC. But I will say that, in summary, I believe the Community Police Commission role is to provide community input so that police services are delivered in a lawful and non-discriminatory manner and are aligned with community values and expectations. But as I say, I'm going to speak to that more directly later. As a friend of mine who has been deeply involved in this process and once told me, the devil is in the details and not in these general consensus items. So my following comments are not intended to be inclusive, but are simply highlights of information supplied to the court from multiple sources. The OPA, Office of Professional Responsibility, as it's referred to sometimes, and sometimes as the Office of Police, along with the Office of the Inspector General, are intended to provide oversight, guidance, and leadership in matters related to police accountability. I have found nothing in any of the material that I've studied to suggest that anyone believes that OPA, as it is currently organized, is sufficiently independent of the Seattle Police Department. I don't want to put words in his mouth, but I believe that OPA Director Mr. Murphy would be in agreement with that. The OPA should investigate allegations of police misconduct in a fair, impartial, consistent, thorough, timely, understandable, and transparent manner. There are different types of violations. There are different types of complaints. They should be treated differently. Part of the work of the OPA should be work with the Seattle Police Department and the Inspector General to make the SPD disciplinary process fair, impartial, consistent, thorough, timely, understandable, and transparent. I have encountered in many of the sources that I have reviewed the difficulty that citizens have of coming in to make a complaint about a alleged police transgression and find that they are talking to a uniformed officer. I believe that needs to change. I think the OPA should support the appropriate role of the Seattle Police Department line supervisors, including in the accountability system, including their responsibilities to mentor and actively manage employees, as well as to investigate, document, and address low-level minor policy violations. The current process before the consent decree was adopted left too many of these complaints having been delegated down to the precinct level and simply disappearing. I believe that has widely stopped, but it needs to be eliminated. My initial belief was that the OPA needed to be housed outside of the Seattle Police Department in order to maintain that independence. Well-informed sources tell me that that would be a bad idea and that the OPA needs access to the Seattle Police Department resources, including access to data systems, personnel, and evidentiary information. Therefore, I have changed my view on that and will be curious to see how the City Council handles the executive's suggestions on it. I believe the OPA needs a budget which has sufficient staffing and resources to effectively do its job. I've indicated already that I think that the sworn positions in OPA need to be replaced by civilians. I believe that the OPA can help this process by having information that they've assembled put up for public inspection, including matters of interest concerning the Seattle Police Department's accountability system. I can understand all too well the dilemma faced by the Seattle Police, who want to have a thorough and complete investigation, and to do that want to maintain confidentiality until they know the facts. I can understand completely the public's view that they want to know what happened the next morning. And I think there is a tension between those two that OPA needs to address. Perhaps doing nothing more than posting timely updates on the outcome of cases, including the status of recommendations that they make concerning changes in practices, will move us in that direction. The office of the director of the OPA should be a civilian with significant legal, investigative, human resources, law enforcement oversight, prosecutorial perhaps, or other legal experience. The director of the OPA should remain a mayoral appointment, subject to some form of confirmation by a majority vote of the City Council. I have struggled with the question of how to reconcile those, and I believe that that's the appropriate method. Much as the chief is responsible for the Seattle Police Department, the mayor and the City Council are responsible for the city. I believe that by strengthening the position of the director of the OPA and strengthening the independence of that position, that we will assist the OPA in doing a better job. I have looked at the proposals submitted by lots of people, going back to the consensus working groups, and I find that there is widespread unanimity in its descriptions of the duties and responsibilities of the OPA chief. And therefore, I'm not going to spend a long time talking about those. Nor will I spend a long time talking about the OPA investigators. As I've indicated, I believe those should be civilians. I believe that we would be able to attract qualified applicants. And I believe that they need to be trained and supplied sufficient resources to do their work in an exemplary manner. There's a major change that the parties have seemed to agree on, and that is to create the position of an inspector general. The parties and the amicus are in agreement that there should be an inspector general to monitor and evaluate the work of the OPA and the operations of the Seattle Police Department. This position, perhaps more than any of the other changes that are contemplated to be made, is the one that strikes me as having the greatest responsibility to carry out long-standing reform, and then to monitor how that reform is working. They should have a staff, they should have a budget, and they should have independence. The Inspector General's primary responsibility should be to monitor the Seattle Police Department, including the FIT teams and the OPA. particularly in the areas of civilian and internally generated complaints, internal investigations, misconduct, policy violations, discipline, use of force, and in-custody deaths. As I previously indicated, the office of the OPA auditor should be abolished, not because she did a bad job, but simply because we're trying to create a new position, which is a more powerful one, and hopefully will address some of the shortcomings that were perceived in the OPA auditor position. Any time that there is an officer-involved shooting or other serious use of force, the OPA and the Inspector General may go to the scene. At that scene, I expect that the integrity of the initial investigation process will be confirmed. It will not be interfered with, but it will also ensure that there is a second set of eyes on what happened. If I had to tell you where that was going to occur, I would say officers involved shootings, death of any person in police custody, use of force that results in the subject being admitted to a hospital or an emergency room, and some others, particularly since the court sees these frequently, canine bites. How should the Inspector General be selected? By the mayor and confirmed by the City Council after a search for the best possible candidate. There, once again, is a lengthy explanation of the kinds of qualifications and responsibilities that we're going to impose on that person, and I'm not going to get into that level of detail. Finally, and importantly, the Disciplinary Review Board should be abolished in favor of a right to appeal to a neutral arbitrator with no ties to the Seattle Police Department. Let me say again that the list that I've just given you is not exclusive. It is not the court that's going to be submitting something to the City Council, but the general outlines of an Office of Professional Responsibility, the director of the OPA, the responsibilities and authorities of the OPA staff, the Office of the Inspector General, the Inspector General, the elimination of the Disciplinary Review Board, and while I intend to address it later, the CPC are all essential parts of a new and hopefully improved accountability structure. At this point, I'm going to ask the parties to exercise their 15 minutes, and I'll start with the government.
Your Honor, if it's okay with you, we're going to actually start with the City of Seattle.
All right. Mr. Holmes, I'm not sure if that was a lateral or a forward pass.
No razzle-dazzle here today, Your Honor. Good afternoon, Your Honor. May it please the Court, I'm Pete Holmes, the elected City Attorney for Defendant City of Seattle. As the Court has directed, I'm here to report on the status of reform efforts underway for the past 4 years at the Seattle Police Department. And I'm happy to report that excellent progress has been made toward reform. It continues to make progress toward reform, and especially in the last 2 years. I'm also happy to report, Your Honor, as I think the Court has alluded, that there is remarkable consensus, not complete, but remarkable among most city stakeholders on the most crucial components for a permanent police accountability system. Balancing my responsibilities under the Charter of the City of Seattle, the rules of professional conduct, and as an officer of the Court, I will also speak to some of the continuing challenges. And as the Court has already foreshadowed, I couldn't help but recalling back in July of 2012 as well, when 5 federal and municipal officials signed off on the consent decree. They include Assistant Attorney General Thomas Perez, former U.S. Attorney Jenny Durkin, former Mayor McGinn, myself, and, of course, Your Honor. And since my present term in office ends next year, it is possible, Your Honor, that you indeed might be the last signatory still standing or sitting at the next status conference. If I might pause for just a moment, Your Honor, I want to make sure that I reintroduce our Chief of Police, Chief O'Toole, who suffers no impediment such as a re-election campaign. But another who is here with us who does is Councilmember Gonzalez. And then also rounding out some of the city constituents that are present here, of course, we have our OPA Director, Pierce Murphy, as well as our OPA Auditor, Ann Levinson. At the outset, Your Honor, let me thank the Court for the order issued last week. It establishes a clear process for the city's legislative authority to proceed with consideration of a permanent police accountability system. And here's what we will do to honor that order. The executive will promptly get to work with council members and other city partners to attempt to reconcile the CPC's proposed accountability legislation with a similar executive package that will be completed this week with the assistance of my office. The city intends to present this single legislative package for the court's consideration by this Labor Day. I also need to pause and express my gratitude as well for the work of the Monitor. The city supports the Monitor's technical advice and recommendations, also released this week, and those recommendations will further inform the city's legislative proposal for the court's review. With the court's subsequent guidance, the legislative branch can then proceed with ample opportunity for robust public comment to refine the details of Seattle's permanent police accountability system. Our City Council will thus ultimately have the benefit of all of the tremendous thought, analysis, and debate that has already gone into SPD's accountability system. Now, the CPC's work culminated last Friday in its own completed legislative recommendations, as the court has acknowledged. I think they seem to be like CPC's magnum opus. Like the nearly complete executive package, both packages have benefited from those weekly meetings, the series of 6 weekly meetings, in fact, that were hosted in my office as a working group in March and April, also with this court's prior approval and direction. This working group, Your Honor, consisted of city stakeholders that included myself and a couple of assistants to make sure that we could handle logistics, take notes, and help track the meeting agendas. Other weekly participants typically included 1, often 2 assistant U.S. attorneys, 1 and sometimes 2 representatives, often 2 from the mayor's office, 1 or 2 senior SPD representatives at least, the OPA director and the deputy director, often simultaneously, the OPA auditor, 1 OPA review board member, and 1, sometimes 2, often 2 members of the monitoring team. There were also no fewer than 4 members of the Community Police Commission present at each meeting. Our meeting notes and agendas constitute public records. Each week, we also met in the mayor's office with council representatives to report on that week's prior meeting. Despite some initial frustrations, the sessions eventually helped us to build trust and identify remarkable areas of consensus regarding that accountability structure. Participants agreed, for instance, as the court has noted, that the chief must remain the final word on all disciplinary matters. Moreover, that an office of the Inspector General should be created to provide a more comprehensive departmental oversight than the current OPA auditor. And while we all agreed that civilian participation input is critical, there was earnest debate over the appropriate civilian institutional vehicle. Through these meetings, CPC ultimately accepted that any change in its current temporary status under the consent decree requires this court's approval. Again, the city's proposed approaches to all of these questions will be presented to the court by Labor Day for review, prior to formal action by the full City Council. In addition to the work on the accountability system, it's important that we today acknowledge that the fundamental reforms that are mandated by this consent decree are proceeding at full throttle in the department. And I would like to further elaborate on some of the progress that the court has already acknowledged. The department has delivered advanced training to both the CIT certified, the Crisis Intervention Team certified, and non-certified officers in a broad array of topics in those instances where we are responding to crisis events. No other agency nationwide, to our knowledge, provides as much training to all officers in crisis intervention and de-escalation as does Seattle. Now, as a result, SPD has one of the highest percentages of CIT certified patrol officers among major city police agencies. This allows for a CIT certified officer to be on scene in nearly 75% of all of our crisis incidents. And Your Honor, because reform must be data driven, SPD has simultaneously implemented a new crisis information template, if you will, that allows for more robust, accurate, and consistent reporting of these crisis contacts. During the first year that this template was in use, and this would be running from May of 2015 until May of this year, Your Honor, the template was in use as Seattle police officers responded to nearly 9,300 crisis incidents, approaching the 10,000 figure. Now, the use of force statistics bear out that our officers are embracing and utilizing this training. Of those approximately 9,300 encounters during that first year, only 149 involved any use of reportable force. That's 1.6%, any use. And of those 149, only 36, or 0.4% of the overall incident universe, involve greater than a low-level type 1 use of force. Now, when we go back 5 years to DOJ's 2011 findings, that 70% of SPD's force incidents involve persons in crisis, these numbers are more than just promising. They are what we are going for, Your Honor. SPD continues to roll out and train officers in many other critical subject areas at unprecedented rates. Our Force Review Board is functioning smoothly and efficiently, and it provides good feedback that informs both training and policy. The data analytics platform is on track and scheduled for rollout by the end of this year. And throughout, Your Honor, this departmental overhaul, SPD is collaborating with researchers nationwide. We're leading in the development of some of the best practices in early intervention, and that's consistent with the White House's 21st Century Policing Initiative. As our national leaders start to understand and recognize that Seattle's policing challenges aren't limited to Seattle, projects funded elsewhere through DOJ grants, they're routinely seeking out our officers developing body of experience and expertise, and we're helping to facilitate those efforts to distribute our training to agencies throughout the country. In fact, Your Honor, we have to date, just keeping track of all of those overtures where agencies are at least reaching out to the department, actually coming here to visit the department. There's a list now of in excess of 50, and some of these are even outside of our country. So, Your Honor, in closing, and as U.S. Attorney Hayes has also pointed out here recently in an opinion piece, SPD is making great progress under this court supervision. Changing the fundamental culture of Seattle policing is a massive undertaking, and much work remains. While the very concept of policing itself is undergoing a rethinking by law enforcement officers, we must stay focused every day in keeping our city safe. Seattle faces incredible demands as the 18th largest city and one of the country's fastest growing. We are grappling, along with our police officers, at the very front lines where widening economic disparities and institutional racism persist. These are all exacerbated by questionable past criminal justice policies that do little more than fill our prisons and jails, together with inadequate funding for education and training, allowing a schools-to-prison pipeline to fester, and a lack of funding, as you have already noted, Your Honor, of funding for adequate mental health and chemical addiction treatment. Our homeless population continues to swell even while we work to reform our police department. Now, I had hoped today to be able to discuss the terms of a ratified police contract with the court. It is unfortunate that the Seattle Police Officers Guild did ultimately reject the agreement that had been negotiated by the executive, but I'm here to tell the court that we remain fully engaged, and the city is committed to working diligently and in good faith to reach a final agreement that fully supports the reform process and all of those objectives. Litigation, I must admit, by some sworn members of the department, likewise presents ongoing challenges, and the court has no doubt read about some of those. But my office remains on point defending the city's reform efforts. In short, despite ongoing challenges, SPD and the city have truly embraced reform. Our efforts continue, and I appreciate again the court's ongoing guidance in that effort. Unless the court has any other questions at this time, I want to thank you for the opportunity to speak at the status conference.
Thank you. Mr. Diaz?
Afternoon, Your Honor. May it please the court, many of my remarks are going to sound duplicative of some of the things Your Honor has already said, that the city attorney just finished saying, but we think it's important to explain the DOJ's positioning at this point in this case on the topics at issue in this hearing, just so you can see what we see from our perspective just a little bit. First off, though, we want to thank the city attorney for convening those discussions, the work group discussions between the various parts of the city. It was quite inclusive. The DOJ and the monitoring team. I want to thank the monitoring team and the CPC in particular for their active participation. It was great having Ron, Mr. Ward, and Mr. Ehrlichman in those meetings, and we sincerely want to express our thanks for their participation in that. Those discussions have led to an important moment for the city. The court has now provided the city with a path for addressing its police accountability systems, a clear path. And as Your Honor and as the city attorney discussed, the discussions have highlighted where there's agreement on those police accountability systems, what those agreements look like, and where issues remain to be resolved. That's important. And the ball is now firmly in the city's court. And it's heartening to hear, as the city attorney described, that the city is intent on moving forward expeditiously. And although I expect people should take this as a given, we want to emphasize that DOJ, both on the East Coast and on the West Coast, stand ready to play its role in the consent decree in this topic. That means for us bringing experience from our work in diverse cities around the country. My colleague Tim McGatt doesn't just work in Seattle. He works in many other cities around the country. He can bring that expertise. We bring also technical expertise from our policing experts. Again, we're offering those resources to the city, to the monitor, to the court. And perhaps most importantly, we will continue to play the role that I think this court expects of the DOJ, which is to ensure that whatever accountability legislation is proposed and enacted is consistent with the consent decree, which we signed, and the Constitution. So I want to keep our remarks very brief here today. We just want to do a couple of things. First, put this police accountability process into a larger frame. And Your Honor did some of that, but we want to do it specifically for this topic in terms of the consent decree and the MOU, the frame of those two documents. And then finally, just touch on very briefly, because I think Your Honor covered a lot of the progress of the last few years, and as did the city attorney just now. And then finally, we want to provide some of the general guidance that you provided, similar to that, but how we will be looking at any police accountability legislation proposed by the city. We think it's important, like Your Honor just did, to give a little bit of guidance for folks to know how DOJ will be reviewing the legislation as well. So the first context, again, is with the consent decree and the MOU. And that's important because that's where this conversation began, as Your Honor stated, and it's where it will end, following the terms, the negotiated and court-approved terms of the consent decree. There are two general points. The first point is the consent decree was largely, and in a very literal sense, silent about the structure of the accountability system. It was the MOU that expressly tasked the CPC with reviewing the structure and recommending changes, quote unquote, for improving SPD accountability and transparency, including reevaluating the roles of the OPA director, the auditor, the review board. And CPC discharged that obligation by providing those recommendations to its city partners about 18 months after its creation, which is impressive. And this is important for us because it actually ties into two goals of the consent decree. The first of these goals is to increase community trust in police by involving the community to make them agents of their own future. Paragraph 1 of the consent decree states, quote, "The parties intend the agreements to provide clear, measurable obligations, while at the same time leaving Seattle with appropriate flexibility to find solutions suitable for this community." So by involving them, we are affecting a goal of the consent decree. The second goal is to leverage community assets at key times on key issues. Paragraph 4 of the consent decree says, "Certain aspects of the reform efforts embodied in the agreement are best developed by dialogue and widespread input." Tim and I, Mr. McGatt and I are not the biggest brains in the room. Getting lots of other brains looking at the same issue is important, and that's a key goal of the consent decree. And we actually anticipated by about 3 years the recommendations of the President's task force on this issue. The task force stated, "Every community should define the appropriate form and structure of civilian oversight to meet the needs of that community." And as we've said publicly before, there are many ways to develop such a system, and the community should be involved in that development. That said, and this is the second major marker here of how we're approaching this issue is, and the court emphasized this in their opening remarks, the parties, the stakeholders all concede that the elements of this new accountability system, both generally and then specifically as previewed in prior briefings to the court, implicate provisions of the consent decree expressly. And because they implicate provisions of the consent decree, that requires the court to ensure they don't conflict with the terms or purpose of the consent decree. And for this reason, the new accountability system ultimately requires court review, and it's essential, and we appreciate the court being involved so deeply and heavily in this process. We think the court's order is appropriate because it strikes that important balance. On the one hand, respecting the proper role of the court and DOJ and its independent enforcement obligation as the enforcer of the consent decree, while honoring the role the community must play in this area specifically. So that's one context. That's how we view the consent decree, the MOU, and your judge's order interacting at this time. The second context is just the context in the reform process. And we're not going to go into any detail on the accomplishments of the consent decree, Your Honor, and the city attorney discussed that very eloquently. We just want to put it in a slightly different lens, which is, much of what drives the interest in this hearing, much of why we have such good attendance today at this hearing, Your Honor, is because often this discussion is focused on officer discipline. When an officer crosses a line, and whether that's a line set by the Constitution or a line now laid out in policy, which can trigger serious and adverse employment actions, that's what gets attention. Will this officer get fired? Will he or she be criminally prosecuted? And that conversation is important, but it's just a small part of this reform effort. A small part of the consent decree, and it's a small part even of the accountability recommendations discussed by the city, the DOJ, the monitor, and the CPC in the work group discussions. It's an important safeguard, the disciplinary system part of it, but it doesn't replace the work being done under the consent decree on the front end. And Your Honor used the word prevention. And so many of the policies, the training, the systems that are now being replicated, as the city attorney mentioned, are focused on that prevention. And again, we anticipated the President's task force recommendations in so many areas of the consent decree. And as the court noted, then that's why we're seeing some of the real progress, we think, in the preventative efforts. The monitor has reported publicly on the improved reporting and investigations, on the diversion of folks in crisis to community resources, on minimizing force. All of those preventative efforts that have been going on for 3 years avoid the need for discipline at the back end, as Your Honor mentioned. And for that reason, we think this accountability structure is important, but should be viewed in the context of these larger preventative reform efforts. So finally, then, we want to just get to our prepared remarks on some of the principles that DOJ expects to see in the proposal the city will send back. Paragraph 164 of the consent decree states, all complaints regarding officer conduct must be or should be fully and fairly dealt with. All investigative findings should be supported by the evidence and documented in writing. Officers and complainants should receive thorough, fair, and expeditious resolution of complaints. For us, when we review this now, that means whatever system is generated, the back end for the court, the DOJ, the monitor's review, have to show a few different things. One is that the investigating arm, Your Honor described it as OPA still, must ensure that there's a continued thoroughness to the investigations. That body must be independent. These are not independent adjectives. These are interlocking. They must strive for fundamental fairness, the investigator, and I'll touch on that in a second, all while doing so in a timely manner. It's a big lift, but those are things that we'll be looking for in the legislation as well. On the fundamental fairness, we'll look for transparency and clarity on various levels. And what we mean by transparency is a process that has a virtue of simplicity, a process that speaks with clarity at the beginning, during, and at the end. And finally, a clear understanding of how these different entities interact, from city leaders to the chief's role to the other components, not just of the accountability system, but the other components of the preventative side, the Force Review Board, the FIT, the EIS, how those things work together. And finally, true community oversight and input. Again, it's not ours to dictate how that is done. Different cities develop transparency in different ways, but that is something we'll be looking for too as we review the proposed legislation. So with that, Your Honor, my comments are done. Unless you have any other questions, I appreciate this time.
Thank you.
Thank you, Your Honor.
Mr. Rez? I think the parties have intentionally or not ceded you 5 minutes more, so.
Okay. I'm only going to take about 5 minutes total, Your Honor. I am Isaac Ruiz. I'm with Keller Rohrbach, but today I'm here in my individual capacity as a volunteer commissioner on the Community Police Commission. Also here today are the 2 co-chairs of the CPC, Reverend Harriet Walden and Lisa Dugard. Our executive director is here, Fel Lopez. Several commissioners from the CPC are here, and of course we've got a lot of community representation here as well today. We're encouraged that the court has established a clear process going forward, Your Honor, so that the legislation can be presented to council and so that we can move from the realm of recommendations to the realm of real, true legislative reform that the public can have confidence in. And as we've said, we are ready, willing, and able to work with everyone in the city to make sure that that happens. The CPC was charged under the settlement agreement and under the Memorandum of Understanding with making recommendations about accountability. Just last week, we issued a set 42 pages of recommendations. And these are building off of the recommendations that came in April of 2014, and they're also building off of the recommendations that were presented as a joint package last summer. The story of police reform in Seattle is a story about the community. So the story about police reform in Seattle is a story about the community. When I was getting ready for today, I went on the docket and I found letters early in the case that community groups had sent to the Department of Justice even before this case was even started. And these are groups like Mothers for Police Accountability, the Multiracial Task Force on Police Accountability. And what we can see is that in these letters, there are very specific recommendations about police reform in Seattle. And these recommendations include specific recommendations about accountability. And one can very easily draw a line from those recommendations before this case even started from community groups to the recommendations that the CPC made in 2014, to the recommendations in last year's agreed package, to the recommendations that we are all talking about today, including some of the things that the monitor has recommended and that Your Honor talked about. At every stage, these recommendations have been refined and they have been strengthened because of extensive public engagement, because of an airing of diverse points of view, technical research, deep technical research on police accountability, and the CPC's partners in the community and in government as well. I believe that the consent decree process as a whole has been enriched and been strengthened because of the CPC's credibility in the community. Since its inception, the CPC has been populated by commissioners who come from diverse sectors of Seattle and who have experience in the community and credibility in the community on police reform matters. The consent decree called for these community representatives to lend their credibility with the community to the reform process, and this has been done. It's not just the CPC commissioners, however. Last November, 47 community leaders and organizations sent the Monitor a letter, and they supported the CPC's approach to oversight. And these leaders have told the CPC that they expect us to continue being their voice in the reform efforts. Will the CPC live on? That's the issue that's been hanging over our heads for the last year plus. And I think that as the consent decree process unfolded, what we have found is that having a commission that purposefully includes representation from Seattle's diverse communities, that takes community engagement extremely seriously, that is willing to do the hard work and conduct extensive technical research, that provides meaningful feedback to SPD on policies and practices, and very importantly, has real credibility in the community. That this is an asset that Seattle ought to preserve and indeed enhance as a permanent part of a civilian oversight system. And this undoubtedly will be a major part of the accountability discussion going forward. The message today from the CPC is on civilian oversight is that a lot of work has been done, and there's a lot more work to do. And we look forward to all of the parties coming together to again move this from the realm of recommendations to the realm of real, meaningful legislation that the public can believe in and that is fully consistent, Your Honor, with the letter and the purpose of the consent decree. Thank you.
Thank you. I reserve some time at the end to speak to two subjects, and then I have some concluding thoughts. The first is a subject that City Attorney Holmes raised, and that has to do with the Seattle Police Officers Guild. Not mentioned very much here today, but obviously something that is involved in this process. The Guild, exercising its complete right to do so, sent me a letter saying we're staking out our turf and don't do anything to invade it because we have rights established under collective bargaining. The court early on in this process asked the internal staff in my chambers to investigate the extent of my authority to overrule contractual provisions when they directly conflict with constitutional principle. The law in that area is not as clear as I would like because my job is to follow the law and not to make the law. But the court is aware of the City of Los Angeles case. For those of you who are not lawyers, and I assume that's most of you, although maybe that's not true, the Guild's letter to me is in the docket. I think it's the third from the bottom these days, being quite recent. And it contains a citation to City of Los Angeles. It talks about the need for a judicial determination of liability before I am empowered to do much of anything. Let me be quite direct on this point. If I see that a labor organization is resisting needed change, I will set a hearing in which the two parties will be the Department of Justice and the City of Seattle, and I will decide if the report issued by the Department of Justice is accurate, and that will constitute ultimately a judicial determination of liability. When that happens, if it needs to happen, the court will be free to make whatever changes it wants to make. I can only assume that the thoughtful management of the Police Officers Guild thought about those questions before the last vote and advised its membership accordingly. But that was a decision that they made, and there is a proposed course of action that arises from it, and it certainly is an option that is available to the court. Well, I'm on the subject of the recent vote, which in many ways is an 800-pound gorilla that's in this courtroom along with the rest of you. I read in the paper, and I'm sure my friends in the press would never write anything that was inaccurate, that the sentiment was expressed that the contract, the proposed contract, wasn't rich enough to justify changes in the current disciplinary system. Not rich enough. Let me once again be blunt. The court and the citizens of Seattle will not be held hostage for payment of increased compensation and benefits to be afforded protections guaranteed to them by the Constitution of the United States of America. I don't know how to be any more direct than that. If you tie additional compensation to elimination of constitutionally unsound institutions and conduct, you are not going to get anywhere in this court. And frankly, I think that the entire city of Seattle would march behind me in that position. Finally, and I once again assume that the Guild fully addressed its membership on this, as long as these collective bargaining provisions are in dispute, I can see no way that the consent decree can terminate. Therefore, I'm going to be here for a long time if we don't come to our senses. I have enjoyed good relations with the Guild. I used to enjoy reading The Guardian until you took it offline. It always was informative and a different point of view. I wish you'd put it back up so that the public can understand where you're coming from. But to hide behind a collective bargaining agreement is not going to work. Second of my two remaining points, or one remaining point in one summary remarks, I address my friends at the Community Policing Commission. Let me once again attempt to be clear about the court's expectations for the CPC. The court is not opposed to the CPC. The current one was created by the terms of the consent decree. That order, or that is now an order of this court. Section B7 of the consent decree says the CPC will have the following distinct roles. And I quote, "The Commission will have the following distinct roles. A, undertake the responsibilities assigned to the Commission in the agreements," and I understand agreements to be the consent decree and the memorandum of understanding. B, the Commission will review the reports and recommendations of the monitor, described below, and may issue its own reports or recommendations to the city on the implementation of the settlement agreement. I congratulate Mr. Ruiz for describing the city's proposed legislation as recommendations. It's not how it's described in your document that you are circulating. It says a proposed legislation. In my mind, there's a difference between recommendations and proposed legislation. That is not to say you don't have a complete right as citizens, you don't have a complete right as 47 community leaders. If you want to propose something to the city council, you have the right to do that. I don't know how you do it, because I've never done it. I know the mayor's going to be doing it, and he's going to be doing it apparently by Labor Day. The Commission, in Part C, may review and issue reports and recommendations as to the implementation of the SPD 2020 initiative and other initiatives of SPD and the city to support the reform process. Once again, issue reports and recommendations. And then lastly, the Commission may consider other issues referred by the parties in Section 3C of the Memorandum of Understanding. As you properly noted, that contains a discussion of a number of the areas that we're talking about today. Consequently, I'm not going to tell you that I'm holding you in contempt for issuing proposed legislation. I just would tell you, please start believing what I say when I say follow what you're supposed to do in the consent decree. And if you don't, then it's going to require me to take some action. And I applaud what you do. I applaud the fact I read your reports, I go to your website, I do all of those things. But I'm not going to let you modify the terms of the consent decree, because that's not something you can do. And I'm not going to allow you to do whatever you want if it's outside the terms of those responsibilities. If you want to change the subjects that the CPC can deal with, or the scope and nature of the CPC's efforts, you need to change the consent decree. Look at paragraph 225. It says, the monitor, city, and DOJ may jointly stipulate to make changes, modifications, and amendments to the settlement agreement. The parties may jointly move for approval of any of the proposed changes, modifications, and/or amendments, which will become effective upon approval by the court. No changes, modifications, or amendments to the settlement agreement will have any force or effect if not set forth in writing, signed by all the parties, and approved by the court. You've got a mechanism of how to change it if you want to change it, but it involves doing something outside the sheer commission itself. Otherwise, you need to stay within the terms of what you're asked to do. The court sees the consent decree as outlining the scope of what it is that you're asked to do. And that is to provide community input so that police services are delivered in a lawful and non-discriminatory manner. That language should be familiar to you because you wrote it. Provide community input. You further agree with that because in your own proposed legislation you say the CPC was originally established by ordinance with responsibilities under the settlement agreement between the City of Seattle and the U.S. Department of Justice. The additional responsibilities of the CPC detailed in this chapter are separate and distinct from Chapter 3.14. To make clear the city's intention that civilian oversight be enhanced and broadened beyond the limited time and scope initially set forth in the settlement agreement in order to better serve the public. Do I want the CPC to be abolished? No. I don't know how many times I got to tell you that. I don't know how many times I have to read in the press that I'm in favor of abolishing the CPC, and the Monitor's in favor of abolishing the CPC. That's nonsense. It is the consent decree that created the CPC, and when the consent decree ends, the CPC goes away. If you want to continue on beyond that point, you have a simple path to get there. You need to go to the City Council and say, we think that this is an important future part, and this is what we propose to do. You've already said what you want to do. You want to be a mechanism for civic input. I see a difference between civic input and management. Some of your provisions cross the line. Lastly, I've spoken to this question of making recommendations, which I applaud you for doing and I think are important. Bottom line to all of this is that if the consent decree is amended and it gives you a new role, then that's your new role. If the consent decree is not amended, then as you acknowledge, the CPC goes out of existence when the consent decree goes out of existence. I can't tell you when that's going to be because it's subject to too many moving parts, but that's the court's view. So, as I heard Mr. Holmes today, he said that the executive's proposal will be submitted to the court by Labor Day. I would expect that 21 days after submission of that document, I will have comments from the city, from the Department of Justice, and from the amicus to assist me in reviewing that for compliance with the terms and that very interesting word used, purpose, of the consent decree. I will now step back from my very precise legal practice and give you the following observations from me. What the court seeks is the following. I want to see clear rules on what are best practices and what is permissive. If we have those clear rules, it's what we owe as a minimum to the men and women who go out and walk around Seattle and proudly wear the Seattle Police Department uniform. But they are entitled to know what they may and may not do. We need to have training on those policies. Sometimes, particularly when the New York Times is in town, the training doesn't go very well. That's an inside joke from some of us. But they need to be trained on them. We need to have an active program of supervision of the activities of our police department. We need to have an accountability system if improper activity occurs. And everything that I have read in the last 5.5 years comes down to one principal point, and that is this requires strong leadership, I think we have the right person to do that in Chief O'Toole. The importance of this issue, to me, is best demonstrated by the news, which was much reported again today. According to FBI statistics, police shootings resulting in deaths involve 41% black people, despite being only 20% of the population living in those cities. 41% of the casualties, 20% of the population. Black lives matter. Black people are not alone in this. Hispanics, Asians, Native Americans are also involved. And lastly, and importantly, police deaths in Dallas, Baton Rouge, Minneapolis, and let's not forget Lakewood, Washington, remind us of the importance of what we are doing. So endeth the scripture for today. Thank you all for your hard work, and this hearing is in recess. Thank you.
All rise, please. Court is in recess.